I'm Vinny Politan. Thanks so much for joining us here on Closing Arguments. And there's a couple of words that you hear a lot in the world of crime and justice. You have the right to remain silent. And we usually talk about that in reference to someone who's a suspect, someone who's a criminal defendant at his own trial or her own trial. You have the right to remain silent, right? And the fact that you remain silent can't be used against you. Well, in the case in Minneapolis that we spent months covering here on Court TV, the trial of Derek Chauvin, that right also afforded to, as it is in every case, to the jurors, right? The jurors. They sit there, they listen to the evidence. The only time they speak is through their verdict. Then they never have to talk about it. They're allowed to talk about it if they want, but they never have to talk about it. They have the right to remain silent. And in the case of Derek Chauvin, they were given some extra rights, which was like the right to remain anonymous. And it wasn't going to be forever, but for a good chunk of time, the judge was going to say, listen, you know, no one's going to know who you are. Just go on, live your life. So you could be anonymous and silent. And you may have heard, Juror 52 has spoken out, spoken about the verdict, given interviews, and all of a sudden now that is becoming an issue in this case because apparently he was at a rally in D.C. wearing a T-shirt, take your knee. I don't know the exact words. We'll get to that in a second. The bottom line here is that we've got a juror speaking out, and now we've got new issues in a trial that I mean, think about all that went into this to make sure that it went correctly, that the jury was protected from the public, and the trial was able to go through with all the COVID protocols, and they brought in the National Guard, and everything worked. Everything worked. And now here we are, we got a juror speaking, and we're getting pictures of him now coming out because he's no longer anonymous. And all of a sudden, issues that weren't an issue are now an issue in this case. So we got a lot to go through tonight because this could kind of turn things on its head. And also, we had some breaking news today that the defendants on this same day have filed their notice of motion for a brand new trial in the case. Let's get to the facts. Let's bring in Court TV legal correspondent Julia Janae. Julia, all this late breaking before the show and really turning things upside down. Let's start first with this motion, this notice of motion that was filed. What is the defense saying? What are they asking for? What do they want?
Vinny, was just filed this afternoon. The attorney for Derek Chauvin, Eric Nelson, filing a long list of things that he believes that the court did in error, that the judge in this case abused his discretion when he made rulings that we heard about during the trial. Let's take a look at some of those key points that the defense says is the reason that they need a new trial in this case. One, they're saying that the court abused its discretion when it denied the defendant's motion for a change of venue. They wanted to move this out of the Minneapolis area to a different county for several reasons, but also that it denied the defendant's motion for a new trial because of publicity during the proceedings that the defense says threatened the fairness of the trial. The court also failed to sequester the jury for the duration of the trial. And they also failed to order Maurice Hall, the passenger in George Floyd's vehicle, to testify. We know Hall pled the fifth, and the judge said that it was okay for that subpoena for him to testify to be quashed. The judge also submitted instructions to the jury that the defense says failed to accurately reflect the law with respect to second-degree unintentional murder, third-degree murder, and authorized use of force in the case. Also that it ordered the state to lead witnesses on direct examination and failed to order that a record be made of the numerous sidebars that occurred during the trial. That we saw those happen on those headsets where all of the parties were able to hear. We were not able to hear. Our Court TV cameras were not able to hear. Now the defense objecting to those not being on the record.
That's, I'm pretty surprised that it wasn't on the record. Most trials that I've covered and when I practiced, all the sidebars, the court reporter would come over. So I assume the court reporter had the headphones on, was writing everything down. But if it's not on the record, that's an interesting issue. The bottom line, though, this is a motion made to the trial judge. And basically Nelson is saying, Judge, these are all the places where you made a mistake, so you need to give us a new trial, right? That's the bottom line with this.
This is typical after a verdict, a guilty verdict, like there was in this case, that the defense will then make their motion for a new trial. More often than not, it is then denied by that judge, but that allows this defense to then go to the higher court, the appeals court, to say that these are the issues we had with this trial, and we now want an appeal for the panel of appellate judges to try and get that conviction overturned. So though this is a common thing that happens after a verdict, it gives us an idea, a preview of what issues they'll be taking to the appellate court.
Absolutely. And I don't see the judge saying that he made a mistake, because he was very thoughtful in the moment that all this was happening. But tonight, I think our focus is going to be on something that is new. And to me, that'll be the interesting issue if and when they put it in front of the judge, which involves this juror, number 52. Let's put it up on the screen. We now know his name. He was allowed to be anonymous, but he, came out and spoke, and he's entitled, he's allowed to speak, right? You can remain anonymous, or you can come out and speak. His name is Brandon Mitchell, juror 52. He was the 6th juror selected. Black male in his 30s, works at a bank, coaches youth sports. All right, nice enough guy. But here's the other part of Brandon Mitchell that is creating some controversy. It's the fact that he attended a protest in Washington, D.C. on August 28th, commemorating the 1963 March on Washington. And there's also a photo on social media that shows him wearing a T-shirt with a picture of Martin Luther King Jr. And the words, "Get your knee off our necks," and BLM. Now, the "get your knee off our necks" clearly in August 28th of last year is all about the George Floyd case. I mean, that's what the case was about. I mean, I, unless there's another case that I don't know about, but to me, it's pretty clear, which could make this potentially problematic. The jury questionnaire, they were asked questions about this stuff, weren't they? About, have you been to protests, et cetera?
I think that's important to point out, that under regular circumstances, a juror is allowed to go to marches. They are allowed to have opinions, to have even political opinions, and still sit as jurors. But this case was very sensitive to the fact that there was a lot of pretrial publicity, a lot of very heightened emotions on these issues. So the court and these parties went through an extensive process with the jury selection questionnaire. And one of those specific questions on that questionnaire was, did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death? And the participants were allowed to, or not participants, but the potential jurors could then answer saying yes, or someone close to me, or no, not at all. They were also asked, if you participated, how much were you involved? And if you participated, did you carry a sign? What did it say? We heard a lot of potential jurors during voir dire who answered yes to that question when asked directly. But what we don't know is how this juror actually answered on the questionnaire, because it is sealed, Vinny. But we know from now these pictures that he did have some involvement. So whether or not he checked yes on that questionnaire, or if he felt that this was in Washington, D.C. and not in Minneapolis as specified in that question.
Yeah, it could come down to the way the question was phrased, and you answered truthfully. You didn't ask me about anything in D.C. Obviously, it goes against the spirit of the question, but that would be on the defense attorney to do follow-up questions or to adjust the questionnaire instead of just limiting it to the protests in Minneapolis. But yeah, the answer to that will be fascinating. We did hear Brandon Mitchell during voir dire, so let's take a listen to some of that.
You were asked a couple of questions about, you were asked a question about the impact to the Twin Cities community in the aftermath of Mr. Floyd's death, the protests, and your response was that you have, there was asked if you think the Twin Cities was positively or negatively impacted. And you responded, neither. The protests have the potential to have positive impact, but I have seen no impact so far. Can you explain what you meant by that?
Meaning, so when I say it has the potential to be positive, it just means that what comes from that just hasn't happened in terms of if there's possibly changes that need to be made. just what needs to happen in general, just in order to see, because like I said, somebody did pass away from this, so something positive either has to come from it or nothing comes from it. Something positive could be, like I said, just simple, maybe a few changes in the way things are handled. I don't know. I don't know what they could be, but I do feel like something positive could possibly come from it. I don't know what negative could come. Like, I'm not the type of person that kind of harps on the negatives. I don't even know what the negative impacts could be personally.
Okay. You were asked a couple of questions about both the Black Lives Matter movement and the Blue Lives Matter movement. You indicated that you have a very favorable impression of the Black Lives Matter movement, and you wrote, Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they're black. Can you just explain that a little bit more?
Explain my answer?
Yes.
Could you repeat what you explain?
Sure. What you wrote is, Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they are black.
Okay.
So, I mean, I guess I'm asking is, I understand that your perception of the Black Lives Matter organization is favorable, but
Well, can I pause you? I don't know Black Lives Matter as an organization.
okay.
I don't know it as an organization. So maybe that's. I mean, I don't know if that's how the question said. I don't know if it said Black Lives Matter organization. I don't view it as that. So I don't.
Okay.
That's not how I subscribe to that.
So I think it's been in previous jurors, it's been sort of somewhat described as a movement on one hand and organization.
I don't think of it as either. I just think of it as a statement.
Okay, fair enough.
All right, so it didn't seem any of the questioning went towards that. So I've got to think if he wrote yes, there would have been questions about that. So I don't know how he answered number 7, the question about the protests in Minneapolis, but he probably wasn't at any in Minneapolis. But the bottom line here, Julia, if the defense knew about that photo, that he wore a shirt that said, "Get your knee off our necks," there's no way that they don't use a peremptory to get rid of him. I can't imagine. I mean, it'd be malpractice, wouldn't it? To say it's okay to have someone on the jury who went to a rally wearing a shirt that says, "Get your knee off our necks," when you're talking about this trial.
Well, I got to point out that quote, and I don't know how Brandon Mitchell feels about it, but it's a quote that can be used not necessarily at just something that's specifically about George Floyd. I know the timing makes it seem that it is that, but
did it exist before George Floyd,
yeah,
though?
it did. It's a quote from Malcolm X. It's not a chip on our
Okay.
shoulder. That's your foot on our neck, knee on our necks, things of that nature. So it's a quote that could have been used in pushes for racial equality. And I don't think Brandon Mitchell, even in listening to his full voir dire process, he does not shy away from the fact that he saw issues with the system, that he was supportive and favorable of Black Lives Matter. And there were times during that questioning and questionnaire, it was a long one, that you could see the attorneys kind of looking back and wondering, okay, what was your answer? Oh, you said you did see the video. Oh, but it says here, oh, it does say that you did. So it seemed that it sometimes was confusing and things could have gotten missed. It's also possible that they skipped his yes on that question, if he did in fact put yes that he had attended a protest. But I do think if the defense had been able to see that picture, if it had been on his social media, they likely would have been able to find it and may have had a lot more questions and would have used a peremptory, because at the end of the jury selection process, they had strikes left over that were not used.
Yeah, and they may have even attempted to get him removed for cause. I mean, for going to a rally and wearing that shirt at the rally, to me, it's problematic, because your job as a defense attorney is to represent the interests of your client. You know what the case is all about. The case is all about him putting his knee on George Floyd's neck. And you've got a juror wearing a shirt saying, "Get your knee off our necks." And it would be absolute malpractice if Eric Nelson knew about that and allowed this guy to stay on the jury without first making a motion for cause, and then if he lost that, using a peremptory, which he had. So, but the bottom line is this: the juror didn't do anything wrong because that question was specific about Minneapolis. So it's either a poorly crafted question or a question that the defense agreed to or didn't follow up on in some manner. I mean, it's really an issue that is like right there, but I don't think it may not be enough for this defense to say, hey, we need a new trial.
It may not, unless they can look at that jury questionnaire, which we are not privy to, but of course the defense has a copy of it, to see if anything in that questionnaire was not truthfully answered.
Yeah, because that's the bottom line, right? You need a juror who's not being truthful. And so far, based on those questions, I don't think the question was ever asked. So then it ends up being on the attorney for not following up. And it seems that might be a logical question. Well, did you go to any protests in Minneapolis? Did you go to any protests anywhere else? Right? I mean, because it could have been in Minneapolis, it could have been one city over, it could have been 2 states over, who knows? But wow, that's really big news tonight, but we'll see how it all turns out. Unbelievable. I mean, every night it's something else. Julie Janae, thank you so much for bringing us the breaking news.